Good morning and welcome. Thank you for joining us for today's special presentation, Self-Settled Life Insurance Trusts, a Viable Alternative. My name is Brandon Centula. I am the Chief Fiduciary Officer of Peak Trust Company with offices in Alaska and Nevada. As many of you know, Peak is a full-service trust company providing customized, flexible, and sophisticated solutions. We welcome the opportunity to partner with you and your clients to help them achieve their estate planning goals. Before we get started this morning, I would like to take care of a few housekeeping items. Today's presentation is being recorded, and we will provide both the recording and slides to all attendees. Please enter any questions you have into the GoToWebinar panel. We will address as many as possible at the end of the presentation. Today, I am excited to be joined by Anthony Vitiello, whom I have known and worked with for more than 20 years. Tony is a partner and chair of the taxation and estate planning practice at Connell Foley. Tony's practice places an emphasis on tax-driven estate planning and asset protection planning. Tony uses a personalized and innovative approach, working with estates from $10 million to those in excess of $1 billion. Tony employs great sophistication in his counsel on significant tax issues for family foundations, closely held corporations, partnerships, and limited liability companies. He also maintains a significant practice in gift, estate, and income tax audits and controversies. Tony has been listed in the Best Lawyers in America, recognized by Best Lawyers in the area of trust and estates, and named by editors of Worth Magazine in its list of top 100 attorneys. A thought leader in estate planning and related tax matters, Tony lectures extensively and frequently publishes in legal and business journals. We are honored to have him share his expertise with us today. And with that, I'll turn it over to Tony. Thank you.
Thank you, Brandon. The Venmo is on its way. I appreciate it.
Absolutely.
So, hello, everyone. When Brandon and I discussed what we should cover today, I thought it would be a great time to talk about self-settled trusts and self-settled life insurance trusts. I guess a little bit about my practice as to why this is so relevant to me and why I do so much of it. When I plan, we have a group of 10 attorneys that I lead, and we have the firm, while regional, is my practice is national and international, and we see a lot of interesting situations. And if there's a plan that takes 10 steps, and all 10 of those steps can be achieved on a very conservative, tried and true basis to accomplish our goals, I am the type of person who will do all 10 steps conservatively. However, in the practice that we have, we are often faced with situations where, while 8 or 9 of those steps can be done very conservatively, maybe 1 or 2 need to be looked at in a unique, or more, for lack of a better word, aggressive structure. And so over the last 20 years, and that's right, Brandon, we've known each other for 20 years. Over the years, I've worked with Brandon in dealing with some of those particular issues, in coming up with the topics and the structures we're going to talk about today. What's really important to remember is these are tools, these are issues, and these are situations that you will all face, and you'll make a decision. And I have no qualms doing what's necessary as long as the client understands the risks and the benefits. And where the topics we're going to talk about today are situations that are not unique to my clientele, and I'm sure you've all faced it, where you might have a widow or widower in their mid-60s who really needs to do some estate planning, but is concerned about giving away too much in terms of assets, all the way down to what we're facing now at the end of this year, with the potential for our lifetime exemptions to go away. And how do we use those and make our clients comfortable? So in the handouts, you will find 2 articles, as well as a PLR. The 2 articles are both articles I've written, one on self-settled trusts and estate planning with them to achieve estate tax exclusion, and the second, which is more of the topic for today, and we'll really focus on it towards the end, is using self-settled life insurance trusts or self-settled trusts to own life insurance. Is it a viable alternative? The way I'm going to proceed and those articles actually, the beginning of those articles explain to you the types of situations where these types of trusts are invaluable in terms of using them in an estate planner's practice. I will say this: I'm a big believer in self-settled trusts when the opportunity presents itself and the need in the particular situation. I have at least one billionaire client who came to me when he was just entering the 9-figure range, and we moved everything into a self-settled trust along the way. And so in excess of 900 million, we believe, will be escape estate taxation. He's 40 years old and single, no children. And other situations where I have significant assets in self-settled trusts. So when the opportunity is right, and the situation warrants, these become necessary tools for estate planners, especially at the high level. With that said, the way I'm going to break this down today is first start off with a review of self-settled trusts and why they generally should not be included in a decedent's taxable estate. I will tell you I have actually had success in audit after someone dies in this area. And I'm sure Brandon could also weigh in on that at some point about his experience on generally broader than my personal practice. But that's the starting point to understand what makes a self-settled trust excludable from a taxable estate, because that's the first step in getting to the life insurance analysis. So let's start. And thank you, Barbara. The other thing is I'm going to ask Barbara to flip pages as we go along, because as I've matured and become more senior in my practice, I've lost all technical ability. The first place to start is on 2036. 2036A1, and it basically says assets gifted by a decedent in trust or otherwise, but for which decedent retained for life either the right to the income from or the possession or enjoyment of such assets. If either of those cases are existent, then the assets are included in the decedent's gross estate. Okay, you can flip, Barbara. In a self-settled trust, if designed properly, the client or the settler does not retain the right to income or principal, for that matter. The operative word is right. But the really important question that we have to ask ourselves is does the client retain, quote unquote, possession or enjoyment of trust assets for life, which would bring those assets back into his estate at death. Barbara, thank you. The second place we have to look in terms of estate tax analysis, and again, this is not meant to be a hyper-technical analysis. I know the audience is very sophisticated. It's really just taking a review of what the rules are and how we get there and why we think these trusts are excluded from a decedent's estate. The second issue is, one back, Barbara, please. Thank you. Section 2038, if the settler of a trust retains the right to alter or amend, revoke, or terminate the trust at death, obviously the assets will be included in this settler's estate. But in a properly designed self-settled trust, and we'll describe what that is later in the seminar, the settler does not retain any such powers. So really 2038 is not the inclusion statute that would be relied upon to collapse this structure. Okay, next page. So really the crux of the estate tax inclusion analysis is 2036A1, whether the settler retain possession or enjoyment of trust property at death. So that's what we're going to focus on, and we're going to look at that as our basis of analyzing this situation. So on the next page, on its face, in a properly designed self-settled trust, there are no rights the settler retains with respect to trust property. They have no right to possess or enjoy the trust property or the income from trust property. Effectively, they're relying on the trustee to make discretionary distributions. So it's a very a paradigm that is based in discretion of the trustees. But where the problem does come up is, so on its face, the statute, you would say these statutes, 2038 clearly doesn't apply. Does 2036A1 apply? Well, where is possession and enjoyment if the trust is fully discretionary? Well, that's where the interesting and important analysis takes place. And Barbara, please, next page. It really has to do with state law creditors' rights. Basically, case law and the IRS authority hold that if a governing jurisdiction's law, i.e. a state's law, allows a creditor of a settler to attach self-settled trust assets or any type of assets, then the settler has retained possession or enjoyment of the trust assets. So that's the key. The key to whether you have estate tax exclusion on a self-settled trust is really turned towards state rights. That case law, and in the articles that I have attached as handouts, you'll see some basic analysis, but you'll see Wells v. Commissioner, which is a TC memo case, a revenue ruling 76-103, a TAM 1999 17001, which are all discussed in the article attachment. And, really 20.2036-1B2 indicates that if the legal obligations of a settler can be satisfied by trust assets, then it's included in his estate, which is really something we're all familiar with, even in non-self-settled, quote-unquote, self-settled trusts. Conversely, there is case law and IRS releases which have stated that governing law does not allow a settler's creditors to attach trust property. If governing law does not allow settler's creditors to attach trust property, the trust assets are not includable in the settler's gross estate. And you'll see that in a few PLRs, 8037-116, 9332-006, German, and a Court of Claims case, German v. US. So those are places where you'd find that authority. Well, what does state law say? And we all know the Bosch case and how state law rights affect estate tax application. And on the next page, most states subject self-settled trusts to creditor claims of the person creating the trust. And thus, by definition, under federal estate tax law, the trust assets are included in the settler's gross estate. Two examples that I'm near and dear familiar with. New Jersey, NJSA 25:2-1 and 3B:11-1. And for New York, EPTL 7-3.1. And again, these are referenced in the first older article. However, several states, including Alaska, which was one of the first, and now Nevada with a relatively recent Nevada Supreme Court case, do not allow a settler's creditors to access self-settled trust property if designed properly. I keep using that term over and over again because we don't have time for the details of how that technically happens in all cases, and that's why I keep using that if designed properly. It's a great legal lawyer's statement. There's a query, however. Some self-settled trust states allow alimony and child support claims that arise after the transfer. So it doesn't really involve a fraudulent transfer type analysis. It involves a new claim arising after the self-settled trust is created and funded. Some states' laws allow a creditor, those types of creditors, to be those claims to be enforced against a self-settled trust that was created by an individual client. So the question is, are ex-spouses and minor children creditors for purposes of gross estate inclusion analysis? These are often called exception creditors. At last look, several of the self-settled trust states had these as exception creditors. I think Delaware is one of them, South Dakota is one of them. Very importantly to note, Alaska does not. And forgive me if I misquote the exact terminology, but as long as a settler who has created a self-settled trust is not more than 30 days behind in his child support or alimony obligations at the time of transfer to the trust, Alaska state statutory law says that those quote unquote exception creditors cannot access the trust. And if you're creating a trust in Alaska, you would probably not do it for someone who's behind on his alimony or child support obligations in the first place, let alone 30 days behind. So Alaska and Nevada are two states that really have the strongest exclusion for creditor access. That, in effect, whether you agree with the principle or not, you have to turn back and ask yourself the question: hey, do the states that have allow access to quote unquote exception creditors after a self-settled trust is created, does that access ruin your analysis under 2036A1, possession or enjoyment? So just keep that in mind when you're doing your planning. As I said, Brandon and I go back 20 years. I have way too many trusts to self-settled trusts to even count. Through Peak Trust based in Alaska and or Nevada. So that's an important factor to keep in mind. Moving on to the next page. So then my question is, all right, with all that theory behind us, does it work? Will a settler of a self-settled trust at death have to include the assets in his self-settled trust in his estate? And the answer is, i.e., do they work? Do self-settled trusts work for gross estate exclusion purposes? And the answer is, well, apparently the IRS thinks so. I wrote my initial article on this topic in 2007, and lo and behold, in 2009, the IRS issued a private letter ruling, which is up on your screen and referenced in the article, and I believe it's one of the handouts, just so I can provide it to you easily. When you read it, you will see there was a self-settled trust, and the settler transferred assets to it and remained a discretionary beneficiary. And the IRS ruled that because, and I'm boiling it down to its very essence, but the IRS ruled because creditors could not access the assets in the self-settled trust, they are not includable in the settler's estate for estate tax purposes. So it's a very powerful ruling. Now, what was I'm going to get to a few issues later, but keep in mind that this was a fully discretionary trust where the settler was not trustee, et cetera, and we'll go through the list of items that you need to keep in mind when doing this. But also keep in mind that this is a private letter ruling. To my knowledge, and I constantly check, but to my knowledge, there is no authoritative release that clearly says what PLR 2009-44002 says. There's also no IRS authoritative release, or even another PLR that contradicts what this PLR holds. So we all know PLRs are not, you can't rely on them for your own clients. But I haven't seen any indication where the IRS is taking a different position. Now, that's not to say that if you design it incorrectly or take risks with the design or more aggressive positions with the design that the IRS won't try. There are a whole host of ways the IRS can chip away at the theory that it actually blessed in this PLR. But right now, I think the theory works, and I've been doing it for almost 20 years. So I'm comfortable with the structure, and much more comfortable now that I have a PLR. I go back to my first statement. Let me digress for 1 second. I go back to my first lesson of the day for myself, which is, if I can achieve something in a more conservative manner, I will do it, because there's no reason to take risk when risk is not necessary. However, there are a number of situations where the client is unwilling to use traditional methods of estate planning to reduce their ultimate taxable estate. We can go through them and hypothesize about all those types. I gave you one example about a widow or a widower. I gave you another example where I have a 40-year-old client who's a billionaire who did not 8 years ago want to part with potential access to all his assets. He was not married. He's still not married. He has no children. His parents are discretionary beneficiaries of the trust as well. But if someday his business dealings led him to a difficult situation, or he just wanted access to the funds and requested them from the trustee, he wanted to know that there was the potential ability, if the trustee agreed, to gain access to those assets. Yet he was smart enough to realize, hey, I have to do something. So when he wouldn't accept all my initial recommendations, I made this recommendation, and it was the right recommendation for him to go forward. Is there risk? Well, there could always be risk if certain things don't play out appropriately, or if the IRS changes its mind. But we'll talk about how to manage those risks later in the program. But again, we have the PLR that blesses these structures, and you can use them in the appropriate places when the risks and the benefits are explained, as opposed to the client not wanting to do anything. Okay, with that said, we'll move on to the next slide. You're all familiar with this if you've ever used the any type of a trust in a self-settled jurisdiction. You need a resident trustee, and these are just some generalities. Some trust assets have to be held in the self-settled trust state. The resident trustee must maintain trust records and prepare or arrange for the preparation of trust income tax returns, and at least part of the trust administration must occur in the self-settled state. So, these are just basic requirements that when you look at all the self-settled statutes, you'll see strains of all of them, and very similar provisions in most of the self-settled trust states. And let's say we've done all that. Now we come to the situation with the next slide, where I ask a very important question, which is, will other states be required to respect self-settled trusts created by a state's resident in a self-settled jurisdiction? Put another way, if one of my New York, New Jersey, Florida, California clients establish a self-settled trust, transfer assets into it, will another state, like New Jersey, respect the law of Alaska in terms of creditor asset, creditor access? Or I think a more appropriate question is, will other states be required to respect the self-settled trusts created by that state residents who are not in the state of Alaska or Nevada, or et cetera? What federal case law seems to indicate, yes. And this is also is covered in my first article, but we have a couple of cases out there, one by the Supreme Court, Hansen versus Denkla, where we had a Florida settler and a Delaware trust and a Delaware trustee, where the Supreme Court would not allow the trust to be accessed by the Florida settlers' creditors. German v. U.S., which is a court of claims case, had some similar issues using in Maryland. So it seems that there might be required a full faith and credit analysis. Now, do I know of any cases that have come out the other way? I do not, where it's a clean case. I believe there's one or two very dirty fact cases out there, which wouldn't be relevant to the analysis, and they were lower court cases. But bottom line is, if you're clean in what you do, you should be able to rely on that. Now, would I want New Jersey to issue a ruling on this? Well, I'd rather keep it the way it is than have New Jersey come out the other way, obviously. So my position is that other states will be required to respect self-settled trusts. Is there risk? Well, you'll have to measure that for yourself, but then we'll talk about ameliorating those risks later in the program. Okay, so here we are. Hopefully what I've done is given you a basic refresher course, which I know you're all already familiar with, on how to set up a self-settled trust from a theoretical purpose and why it works um, for estate tax exclusion. So after the 2009 PLR came about, here's the situation I became faced with. I deal with a lot of financial planners in my practice, as I know most of the attorneys and accountants out there do so as well. There was a group or a subset of those financial planners who believed in insurance that had very significant cash value components to the policies. And I always scratched my head in that, okay, these are very sophisticated estate planning financial advisors. They know the rules. Yet they're having a very wealthy client put in place very significant insurance policies that would accumulate very significant death benefits over time, with the understanding that, hey, you want to maintain access to the cash value in the long run. You know, a lot of this you might see with younger people who are on Wall Street and earning a lot of money in their 30s and early 40s, but, you know, concerned what happens 30 years from now. Will I have access to the cash value if my income stream dries up? Or hey, we'll use this as a supplemental retirement plan, as another subset of planners often does in terms of accumulating cash value and then borrowing against the policy at older ages without income tax issues, i.e. a income tax deferral device. Yeah, and you could probably think of a few more that I'm not mentioning here. But in every one of those cases, the client would retain ownership of the policy. And in every one of those cases, if the client died, the death benefit would be included in the client's estate for federal estate tax purposes. So with those planners, you know, and I understood their objectives, and was there a way to achieve the client's objectives of retaining, potentially being able to access cash value years down the road, yet still have the policy excluded from the client's estate? Now, I will start off with this statement. There are no authoritative or unauthoritative rulings with what we're about to talk about. This is an extension of the PLR analysis coupled with an analysis of IRC section 2042 and the authorities thereunder. But here's the problem. You have a client who already has an estate tax issue. They are interested in an accumulation policy, i.e. cash accumulation policy, yet and don't have another alternative to achieve their goals of excluding the policy death benefits from their estate if they die prematurely. So with that dilemma in front of you, is there the potential for another option? And that's when I came up with this potential theory of why not have life insurance owned by a self-settled trust. I think it's a great solution to the issue because if you don't do anything, the policy will definitely be included in the taxpayer's estate when he dies. But the solid theory surrounding this analysis gives estate planners the option to have a policy purchased in a self-settled trust. And if down the road, for cash accumulation, and if down the road the client needs access because of the discretionary nature of the trust, the client can ask the trustee for a discretionary distribution. That's the theory we work under, and that's why you would be motivated to take this stance, especially earlier in life when the client is unwilling to transfer the policy into a traditional or buy the policy in a traditional life insurance trust that would be excluded from his estate. In other words, the client will not do the traditional planning, and this is an option that gives them possibility of having the policy excluded if they do die prior to the policy being used for its intended purposes. Okay, with that said, let's look at the theory. Actually, Barb, if you could go back to the first the one, thank you. We're all familiar with IRC section 2042. If a decedent retains any incidents of ownership, that's in quotes, that's the key language, in a policy ensuring his or her life at death, the proceeds of such policy are included in the decedent's gross estate. Very simple. But what's the next question? What's an incidence of ownership? And again, 2042 is the key statute for determining if a life insurance policy is included in the grantor's estate or any estate. This is actually an addition. Think of it as a building block. We're assuming you've already structured the self-settled trust to meet all the other requirements of being excluded from the grantor's estate. Now we're going to look at, can we add insurance on top and still achieve the same goal, even with the life insurance policy? So the incident, so Barbara, we can go to the next slide and we'll look at what incidence of ownership really entails. And the term, as you all know, is broadly defined. Both the Treasury regs and case law enumerate them to include, among others, the power to change beneficiaries, the ability to surrender the policy, the ability to sign the policy, pledging of the policy as security, borrowing from the policy, having a reversionary interest in the policy one way or the other, the right to insured's right to the economic benefits of the policy. And remember, these are all rights. Potentially the power to remove and replace the trustee of a trust, and being the trustee of a trust that owns life insurance in question. These are all potential issues that could be viewed as an incidence of ownership. And on the next page, Barbara, if you could flip to the next page. The IRS has issued a number of PLRs and actually one revenue ruling, all allowing a trust to purchase insurance on the life of a beneficiary. So this is the beginning of the analysis. We know we have 2042. Now, how far has the IRS actually gone in saying, hey, here's the roadmap for understanding what powers that an insured can have and not have over a life insurance policy for that policy or the proceeds therefrom to be included in the insured's estate at death. So all of these releases that we're about to talk about do not, capital N-O-T, do not involve self-settled trusts. They all involve trusts where the insured is a beneficiary of the trust. Again, let me state that the insured is a beneficiary of the trust. The trust was not created by the insured generally. And that's an important non-factor. There's revenue ruling 84-179, which is a key revenue ruling in the analysis. And then you have a string of PLRs which cite it. All of these involve trusts for the benefit of a spouse. The second bullet point involve trust for the benefit of a spouse where the trust owned survivorship policies or a single life policy ensuring the life of the spouse beneficiary. So those are key components. The IRS allowed basically said that the insurance proceeds were not included in the spouse's estate within certain requirements. And then the last two PLRs on that page involve trusts for children who are beneficiaries, and those trusts where they are beneficiaries on own policies on the children's lives. What you'll find is the IRS basically did not include the proceeds in their estate because the beneficiary / insured took certain steps to divest themselves of any powers that the IRS may have considered would be an incidence of ownership over the policy. And in a couple of slides, which I'll get to, you'll see what I mean by that statement. But I'm just getting to the fact that the IRS has blessed numerous situations where we see a beneficiary of a trust who is also the insured on a policy owned by the trust over which he's a beneficiary. So if we flip the page, in all of these PLRs and the revenue ruling, and I think it's because they all cite the revenue ruling, the IRS mentioned, and some might say relied on the fact that the insured beneficiary had not provided the funds to pay or the consideration to pay the life insurance premiums. And I don't think that's a 2042 factor per se. If there was an obligation to purchase the policy, yeah, you're getting into 2042. But if the client is just gifting funds to a trust and it's really in the discretion of the trustees, I don't see that as a 2042 issue. You could argue that if there's consideration, you could view it as a 2036 possession and enjoyment argument. But I don't think that is a winning argument in the end. Or let me rephrase, I don't think that's what the IRS was getting at. But that requires a whole long discussion, which these are referenced in my article. And in all of these PLRs and revenue rulings, remember, there's no indication that creditors of the insured could access the trust assets. This goes back to the possession enjoyment argument. In all of the PLRs and the revenue ruling, the IRS approved of the trust owning a policy on a beneficiary insured's life, and the proceeds were not included in the beneficiary insured's gross estate. And I cited all those PLRs, but the IRS position on estate tax exclusion has not changed. If Barbara could go to the next slide. You see we have recent PLRs that really hold the same thing. And then we'll just flip so their position hasn't changed over the years. On the next slide, let's talk about how you create a self-settled trust that can own life insurance on the settler. So let's talk about design issues. So we're getting into the really important pieces of this. So the structure of a trust that potentially would own life insurance on the settler / beneficiary's life needs to follow, first of all, the same rules as other typical provisions you would put in a well-designed self-settled trust for estate tax exclusion purposes that didn't have insurance. And those include, the list is right there. The settler can't be a trustee or a co-trustee. The trust must be fully discretionary, i.e., I would not put in a HEM standard. I would not put in mandatory income. Those are clearly possession and enjoyment rights. A no 5 and 5 power and no power of appointment for the settler. Those are clearly rights that will, in my view, ruin the estate tax exclusion benefits of a self-settled trust. I wouldn't even give the remove and replace power to the settler with respect to trustees, even under our beloved revenue ruling that allows this single power standing alone not to cause estate tax inclusion. And the reason I don't want to give it to a settler is in a self-settled trust situation is, well, standing alone, we all know that power works in a normal, plain vanilla, third-party settled trust. But in a self-settled trust, that power coupled with the settler being a discretionary beneficiary, I think will give the possession enjoyment argument under 2036 a very strong success. Perhaps you have an adverse party as a trustee. Well, if there's often people want to use their children as trustees. Well, if the child is a discretionary beneficiary, I think you get there potentially. So that's an issue you have to consider. You cannot have a requirement. Now we get into some specifics. You cannot have a requirement that the trust purchase insurance or pay insurance premiums in the trust or use any contributions that are made by the settler to purchase or maintain the insurance. These are the same. That's a similar rule to what we do anyway in normal, plain vanilla third-party trusts. But it's very important that the trustees do not have any requirement, but you obviously give the trustee the discretion to purchase whatever investments he or she sees fit. In sum, the settler has no rights at all under the trust, no rights. The one query I would give you is, in a lot of my self-settled trusts, or actually in every one of them, we have a role called the protector. We do not give the settler the power to remove and replace trustees, but we do give the protector, as it's really its sole function, his or her sole function, to remove and replace trustees. So the question is, do you give the settler the power to remove and replace the protector? Good question. It is a step removed. It's a harder argument. I could see you arguing in favor of that. But I'm not going to answer the question directly, and I'm going to allow you to use your judgment if you're ever placed in this situation. So let's go to the next slide. I think I've given you the effective rules for how to set one of these up to make it work for the right argument under both 2036A1 and 2042 to avoid inclusion in the settler's gross estate. These are the practical considerations. Why use a self-settled trust for estate planning? Well, I think I've given you a few of those already, some examples with my clients, but it's really the client who won't do further estate planning or only will do a limited amount of estate planning, yet still have a very significant potential estate tax bite. Now, in self-settled trusts without insurance, it could be that the settler doesn't want to buy a policy big enough to insure his risk. And that's when the self-settled trust without insurance might come in place. But for self-settled trust with insurance, well, I think the younger client that wants, or any client that wants to keep access to the cash value, might consider this as an option if they're unwilling to do anything else or unwilling to put the insurance policy into a normal life insurance trust that benefits spouse and/or children. What's the risk versus reward? Again, the risk is potential for issues coming up that would allow gross estate inclusion at the settler's death, or the IRS changing its view from the PLR we love and worship. The reward is, if you do it correctly and you're very careful and the IRS position holds, the assets either in a self-settled trust or a self-settled life insurance trust will be excluded from the client's estate where there was no willingness or option to do any other type of more plain vanilla conservative planning. Okay, well, you could see a 30 or 40-year-old doing that with his very significant policy for which he wants to retain access to cash value on a discretionary basis. We know what the risks are. Tony, what happens now he or she is 65 years old and looks back and says, well, with my assets, I don't even need this insurance or cash value access to it. And this might apply to a normal self-settled trust as well, where you don't have insurance. You use backdoors. You use decanting as your solution. You transfer, because the terms of the trust are not only for the benefit of the settler, that's for the benefit of the settler's issue generally, or other beneficiaries, and because you have language that says distributions can be made effectively directly to the beneficiary or to or for a trust for the benefit of any one or more of the beneficiaries to the exclusion of others, you can actually, just by the terms of your good drafting, move it from a self-settled trust or a self-settled life insurance trust, any one or more of the assets, to a plain vanilla trust. And in the long run, that will hold. So backdoors and decanting are, how you look at exit strategies in the long run for this. There's one more topic. We're really doing well in terms of this time. There's one more topic I want to cover, which is on the next page, Barbara, please. And this is very relevant to the next 4 months. we are all getting the idea that the odds or the polls tell us there very well could be a Democratic administration and potentially a Democratic Senate. If that happens, we know that, and holding the House seems pretty easy for the Democrats, from what I understand. We know that the Democratic platform, and I make no political statements, but the Democratic platform does have a proposal that brings the exemptions down from the very high 11.58 million to a number much lower, which I anticipate could be 3.5 million per person, i.e. a loss of over $7 million in available gift and estate tax exemption. So clients are now getting on board to saying, oh my God, I need to deal with this. I need to give this away before the end of the year, because if I wait till next year, the exemption might not be there anymore. So the big argument I am coming across is, what do you do to preserve exemption? Yet for most clients who are in the 10, 20, 30, $40 million range, giving away $23 million plus in assets is a big hit to their net worth. A $100 million client doesn't really care about that. But what are the planning techniques? And I'm hearing consistently the recommendation to use non-reciprocal slats, spousal lifetime access trusts. And that, just to paint the picture, is one spouse creates a trust for the other, and the other spouse does the same thing in reverse, except what do you have to do to make sure the estate of grace does not apply to collapse them? Well, clearly the terms have to be different. Maybe the trustees should be different. You might want to fund them at different times, and I'm a believer you never sign them at the same time, although I've heard people take different positions on that. So putting aside those differences and arguing what's wrong and right in terms of what really is required, the big issue is, if spouses do this, let's say they're worth $25 or $30 million and they each use up their exemption to put it in trust for the survivor, you got to tell them, well, if one of them dies, you lose access to half of your net worth. And you have to disclose that, and that's the right thing to disclose. And you'll see in about 80% of the cases, in my view, they'll look up at you, their eyes would go wide and say, are you kidding me? And I would say no. And then a great insurance advisor would come in and say, well, that's okay, because each slat can purchase life insurance trust on the creator, the settler of that slat, so that if one spouse dies, then the other half of the assets that are lost would be made up with insurance. That is a possibility, yes. What happens if one spouse is not insurable? What happens if the insurance costs are way too high? What happens if they're not there's no relationship where you could have reciprocal slats? They're single, divorced, widowed, etc. So the insurability issue, of feasibility of a single life policy is questionable, or they're not in a position to do that, or they're just not, no matter what their like or dislike for insurances, they're uninterested in setting up reciprocal slats. So with that said, and one other problem that I see is, if this is going to start happening now with slats, as I said, I'm a big believer in putting space and time between them. You don't really have much time to start the first one to have the second one signed and funded by the end of the year. So this is where your self-settled trust comes into play. If you get that kind of reaction with clients who are unwilling to fund these types of trusts and lose access to half their assets, you have one spouse create the self-settled trust where they're both discretionary beneficiaries. So regardless of who dies first, the survivor will have access to all the liquid assets. And another component you can layer on it is a self-settled life insurance trust. Use it as a self-settled life insurance trust as well, not having to buy a single life policy, which might be not feasible either by cost or insurability. You can do it much less expensive or more easily insurable second to die, if cash value is an important structure. Or you could do any combination, create a truce non-self-settled survivorship trust that can be funded by the self-settled trust assets because the discretionary a beneficiary are the children or a trust for the children, or separate it out and do one self-settled trust just for hard assets and another for a large cash value second to die policy where you can shift over assets from the liquid self-settled trust to the self-settled life insurance trust and just have um, separation of asset classes in case the theory on life insurance self-settled trust does not ultimately hold up or there are issues along the way. With that said, I think that gives you why you create a self-settled life insurance trust and a self-settled trust and the legal parameters and theory behind it. It's all a calculation of risk and reward, and that's how I look at the practice area and these types of trusts. From that, Brandon, Barbara, I turn it back.
Well, Tony, thank you for your excellent presentation. It was timely, informative, and worthwhile. I learned something new, and I'm sure that others did as well. If you have time, Tony, we have a number of questions. Is it okay to ask a few questions of you?
Yes, please.
Great. So first question is from Laylit. In a traditional ILIT, how does cash value get accessed where client is not beneficiary? Is this an advantage of self-settled life insurance trust?
So the answer to that question is in a traditional life insurance trust where dad sets up a trust for children or sets up a trust for a wife, the trustee has the ability to access cash value in his discretion from the insurance policy owned by the trust. The problem is the settlor can't have a distribution of that cash. The distribution can only go to the normal beneficiaries who are either the spouse or the children. And that's the problem with not using a self-settled life insurance trust. If the settlor wants potential access to the cash value through the discretion of the trustee, it has to be a self-settled life insurance trust.
Makes sense to me. Probably very little risk if you have a long-term stable marriage, I assume, and if it wasn't a self-settled trust. Mm-hmm.
Correct.
Great. Question from Gary. Does the purchase of life insurance on the settlor of a self-settled trust make the trust a grantor trust for income tax purposes? If so, what are the implications?
So it would be a grantor trust. You would design it as that no matter what. But the implications are that the grantor would be taxed on any non-life insurance income generated by the trust, just like a normal life insurance trust would be set up as a grantor trust, and if it owned other assets, the grantor would be subject to income tax on the trust income.
Okay, thank you. Let's see here. Question from Arthur. Why can't total discretion incorporate the ascertainable standard health education maintenance and support standard qualified by total discretion?
Ooh, that's a good question, and you'll find that, my guess is you'll find that different states have different rules on this. But in basic theory, a HEM standard is an objective standard when you boil it down. Within parameters, a judge will be able to say you've met that standard or not. A fully discretionary standard is a standard which says the trustee could do effectively, except for malfeasance, make distributions or not make distributions. If your intent is to give guidance to the trustee and not put mandatory requirements within parameters like a traditional HEM standard, then you can certainly put in precatory language into the trust by saying, first of all, set the distribution standard distribution is fully discretionary, but say, hey, but it's my intention that these things be distributed, and obviously it's in your discretion. But that's precatory language in my view. It's not enforceable. The real standard is the fully discretionary language.
Thank you, Tony. I've got a question from Chuck, and it's a little off topic, but Chuck asks, we know we are discussing life insurance, but would a state court be able to assert jurisdiction over real estate located in the jurisdiction, presumably of the settlor, even though it is owned in a self-settled trust set up in another jurisdiction?
The answer to that is yes, called in rem jurisdiction. Property's in the state. State court has authority over it. That's why putting real estate, the step one best is to put the real estate into an LLC and not have the real estate owned directly. It still should work in terms of owning the real estate directly, but I've never taken that chance. I've always made it a non-real asset.
Great. Thank you, Tony. And for what it's worth, that's Peak's policy. When we have non-Alaska or non-Nevada property, we require that it be owned by an intermediary entity like an LLC or partnership. Tony, do you think a gift to the self-settled trust, is it complete upon funding or upon running of the statute of limitations?
Well, a gift from gift tax purposes is complete upon the transfer. The value of the gift can be challenged by the IRS 3 years after the filing of a gift tax return that has adequate disclosure. So a gift is complete when it's made by basic definition. So if you cash into a self-settled trust, it's complete when it's made, assuming it's designed as a completed gift and doesn't run afoul of those rules.
Okay. Got a question from Phoebe. She asks, and this is in regards to the trust protector provisions you spoke about earlier. Who fills this role typically? Is it an attorney? Is it a professional corporation? Is there a company or corporate fiduciary that you generally name? Do you ever name yourself?
Yeah, so I believe I have thousands of trusts with protectors in them, and while all different people can play that role, I've been asked too many times to remember. And have done it, but there's nothing to do while things are going well. I've never seen a corporate trustee serve as a protector. It's usually someone who the settlor is very comfortable with and has as their primary concern the settlor's welfare. And that's usually a personal relationship one way or the other.
Sure, makes sense. Okay. Got a question from Jason. Jason asks, don't states like New York and others prohibit self-settled trusts from taxpayers in their states being established in other jurisdictions like Nevada? Meaning,
go ahead.
Meaning, I think, is will New York go after a resident taxpayer who established a self-settled trust in Nevada? I'm not sure if it's a tax question or if it's a asset protection question.
Yeah, so my guess is that's an asset protection question. And I think the question is, will a New York court seek to enforce a judgment against an Alaska trust created by a New York resident? Although the question does have implications for estate tax exclusion under 2036A1. Because if New York law allows and doesn't respect Alaska's law, which they might be required to do under federal law, I could see that happening. And that's why, all the trusts I've discussed are estate planning trusts. I think that you might have issues in those circumstances when it's purely an asset protection trust, and that's what in the end could arise as the problematic issue.
Great, thanks again, Tony. So hard to believe that we've consumed an hour of everyone's time this morning. We've got a few more questions coming in. Let's see here. Meanwhile, I just want to remind everyone that we will be sending the recording and the handouts and the slides to every attendee today. So we've got time for one more question. So this one is from Ronan. Are tax implications of a self-settled trust different from a normal life insurance trust?
Assuming both are grantor trusts for income tax purposes, they are identical. In other words, the grantor will be taxed on all the income and get all the tax deductions on any tax attributes in the trust.
Well, thanks again, Tony. I appreciate your time and your excellent and wonderful presentation. Thank you to all those who attended today. Again, as a reminder, we will be sending the recording and the handouts and slides to everybody who attended. If you have any questions regarding Peak Trust Company and its services, please contact me at 907-278-6775 or by email at bcintula@peaktrust.com. If you have any additional questions for Tony, you can email those to me as well. We'll make sure that he gets them. Thanks, everybody, and have a great day.
Thank you.